for being here with us today. We're excited to share with you the product of our 6 months of research on the juvenile justice system in Washington State. The journey of collecting data and grappling with it to come to some conclusions about the current system has been challenging but rewarding. We hope you'll be just as intrigued by our data findings as we are. As you may know, under current Washington state law, juveniles may be housed in adult jail if declined to adult jurisdiction for certain offenses. Over the course of our research, we have closely examined this policy and sought to understand what can be said about its implications, both on the lives of the juveniles and on the wider society. This presentation will highlight the most unique and noteworthy findings documented in our report, which you all have, and so will not cover the full scope of our research, but we'll openly welcome questions in the end to delve further into our data. From our findings, we'll offer a series of policy recommendations in hopes to better the current system. And now Martha will give you a little background on declination in Washington.
So our early research revealed that a juvenile's path to being housed in an adult jail begins with the declination process. And this process is initiated by the prosecuting attorney's decision to file charges against a juvenile. Based on the charges that are filed, the juvenile can be transferred from the juvenile system into the adult courts. And this occurs in two ways. One is automatic declination. Most transfers in Washington state occur as a result of automatic declination. And this takes place when a juvenile is charged with a serious violent offense, such as murder, rape, or homicide, or is charged with a violent offense and also has previous criminal history. There's a table, figure 1.1 in the report, has a full list of all charges that can qualify a juvenile for declination. Alternatively, juveniles can also be declined via discretionary declination, a process that can be initiated by a variety of court actors or even the juvenile themselves. After this, a discretionary decline hearing is held, during which a judge hears the facts of the case and evaluates the juvenile's life circumstances, background, and criminal history. All of these are assessed in light of the Kent factors, which are a series of guidelines that allow judges to assess the juvenile's maturity, level of sophistication, and potential for rehabilitation in determining whether they should stay in the juvenile system or be transferred to the adult courts. So just to give you a brief overview of the facilities we'll be discussing throughout the report, this is just kind of a brief overview. We actually had the opportunity to visit several of these facilities as part of our research. So the facilities for detention are primarily divided between short and long term. The juvenile detention centers are the short-term housing facilities for juveniles. Youth can be housed here both pre and post-sentence. They are primarily rehabilitative in nature, and they offer a wide variety of programs and services for the youth who are housed there. And there are only 21 JDCs in Washington state, so many of these JDCs house juveniles from multiple counties, especially counties that aren't large enough to have their own JDCs. Although, as you'll hear later on in the report, sometimes this doesn't always happen. The adult facilities that are parallel to JDCs are, of course, jails. They're also designed for short stays and for sentences less than 1 year. They kind of have a more punitive approach to detention than JDCs and don't offer very many programs. The services offered are pretty minimal compared to JDCs. And then long-term facilities, for juveniles who are sentenced to longer periods in detention, they are housed in facilities run by the Juvenile Rehabilitation Administration. As the name suggests, these facilities are rehabilitative in nature, and they offer a wide range of academic and vocational programs there. There are 4 JRA facilities in Washington state. 3 of them house male offenders, and 1 is designed specifically for female offenders. The adult parallel to this are obviously the prisons run by the Washington State Department of Corrections. Adult offenders who are sentenced to more than 1 year in detention are sent to prisons. Like jails, prisons have a more punitive rather than rehabilitative approach to detention and don't offer the same kinds of programs and job training services that are provided at JRA. And through an agreement between DOC and JRA, juveniles who are serving sentences that would go past their 18th birthday are allowed to stay at JRA facilities until age 21, provided that they maintain good behavior. And now Liz will guide us through our research questions.
So given the different philosophies between the two criminal justice systems, where a juvenile offender is housed becomes very important. But in spite of this, we found that not much research had been done in Washington State about the declination process and the juvenile experience in jail. In order to address this, Columbia Legal Services posed the following research questions. What is the size and demographic composition of the youth population held in jails in Washington State? How did these juveniles come to get there? And what are the collateral consequences of youth spending time in jail, both for the individuals and for society as a whole? And in order to answer these questions, we first attempted to gather statistics from the Sentencing Guidelines Commissions and the Administrative Office of the Courts, both of which are statewide data collection agencies, but we found that neither of these offices actually had complete information. So instead, we proceeded to contact each individual county. We first did this by calling the counties themselves, but this proved to be rather ineffective because we were often not put in contact with the correct person, or we left voicemails that went largely unanswered. So then we decided to streamline the process by sending out a general information request to each county, and a copy of this information request can be found on page 34 of your report. This general information request is different from a public records request because a public records request only requires that a county supply the inquirer with already existing data or documents. And because we were looking for answers to specific questions, we decided to generate our own information request. So we sent out these requests in November 2012, and they asked for the following information. The number of juveniles held in jail between January 2009 and October 2012, with juveniles being defined as anyone under the age of 18, and these dates were chosen simply because we were looking for the most recent numbers going back 4 years. We also were interested in the age of juveniles in jail, the most serious offense associated with the decline, the booking and release dates of the juvenile, any other charges filed, as well as the race and gender of the individuals. And we also asked the counties for any policies that they may have regarding the declination of juveniles, as well as any services offered to them. If the counties had not responded by January 2013, we then proceeded to follow up with emails as well as phone calls. And if they hadn't responded by March 2013, we declared them to be non-responsive. Qualitative data about juvenile experience in jail came from two sources mainly. First of all, we went to Green Hill, which is a medium maximum security facility run by the JRA, and it houses all declined male juveniles in Washington State, and so we conducted interviews there. And we also interviewed jail administrators, jail and JDC staff, prosecutors, judges, and defense attorneys about juvenile experience in jail. And then, as Martha mentioned earlier, we also toured the King County Regional Justice Center and the Pierce County Jail, as well as the JDC facilities in both Pierce and King County. And now Max will discuss some of our noteworthy findings from our quantitative data.
So the following section we're about to go into details the aggregate county data that we collected from each of our county information requests that Liz just mentioned. 18 counties reported that they do hold juveniles in jail. 14 counties reported that they do not hold juveniles in jail, and 7 counties did not respond to our information requests. Those 7 counties are Ferry, Jefferson, Pacific, Okanagan, Klickitat, San Juan, and Asotin counties. Fortunately, these 7 counties are all among the least populous in Washington State, so we do not believe their lack of response in any ways will affect our statewide trends or numbers. And it's also important to note that Clark County, as the fifth most populous county in Washington State, while they did respond and say that they held juveniles in jail, they did not give us any exact numbers. Based on our best estimates, we estimate that they held about 70 juveniles in jail from January 2009 through October 2012. However, we did not include these in our data because we couldn't give an exact number. We also don't believe that their lack of inclusion affects the statewide trends in any way. Let's move on, Mark. Before we get to the data, it's important to understand what our data represents and what it does not. It does not represent the number of unique juveniles who've been declined and held in Washington State jails. What it does represent is the number of juvenile stays in adult jails in Washington State, which means that one juvenile under 18 could be counted multiple times in our data set if they either recidivated through a new charge or through a probation violation.